Ah. Hello, everybody. Welcome to Winthrop University. Thank you for joining us for tonight's event. My name is Katerina Moyen. I'm the director of the West Forum, and I'm happy to be here to introduce our speaker tonight. But before I do, I would like to ask you to make sure that your cell phones are on silent or very, very quiet. You are certainly welcome to take notes on any electronic devices that you have. Just make sure that those are on silent as well. When the impeachment trial of President Trump began last fall, Winthrop students across the university asked various faculty about the impeachment process and its implications. They wanted to understand what was being done, why was it being done, and what the long-term consequences might be. To begin to answer these questions, the Department of Political Science hosted an address by Dr. John Holder, who walked us through the constitutional background of impeachment and followed up with a Q&A session about the impeachment rules. Tonight's event is a continuation of that conversation, and it is our attempt to continue to answer our students' questions about impeachment. We will look at the facts of the impeachment trial now that it's completed, and we will attempt to understand what lawyers, constitutional scholars, congresspeople, and we the people can learn from it. It is in this spirit of inquiry that we bring you tonight's event. South Carolina Humanities, the Departments of History, Interdisciplinary Studies, Political Science, and the West Forum all welcome you here to join us on this journey. As you listen to our speaker, please consider the issues raised with the goal of learning and processing what occurred during the trial, especially in relation to its long-term historical significance. We will have a Q&A period at the end of the presentation where you will be able to address questions to our speaker. We also ask that you complete our 2-question survey, which is going to come up on the screen when I'm finished talking, assessing your learning about tonight's event. It helps us put together programming that meets your interests and needs. Now let me introduce you to tonight's speaker. Dr. Michael Gerhardt is a Distinguished Professor of Jurisprudence at UNC Chapel Hill. His teaching and his research focuses on conflicts between presidents and the Congress. He's written 6 books and over 50 articles on these topics. 2 of his books are called Impeachment, What Everyone Needs to Know, and The Federal Impeachment Process, A Constitutional and Historical Analysis. Dr. Gerhardt has testified more than a dozen times before Congress, including as the only joint witness in the Clinton impeachment hearings in the House. He also testified during President Trump's impeachment hearing in the House this December. At Winthrop today, he's going to discuss what happened at the impeachment trial and what we've learned from it. So let's all give him a warm welcome.
I want to thank everybody for being here today. I want to thank you for the great opportunity and honor and privilege to be able to talk to you about impeachment. Since we're a relatively small group, I want to make this relatively informal, so I will keep my remarks relatively brief. But what I'm going to talk about is a little bit of who I am, where I came from, why I'm interested in impeachment, and particularly, of course, what may have just happened and how do we make sense of it. But before I even do all that, I have to note something personal. I'm the father of 3 boys, one of whom is in college. My twins are 17, and today they just registered to vote. And one of them just started trying to vote about 10 minutes ago. He has yet to finish. And so in our family, we're going to see whether I finish first or whether he finishes first. So far, he's still going. And my wife just sent me a text saying he made a mistake, he's got to start all over again. So I'm betting on me that I might actually finish first. It's fitting, of course, that we're all concerned with the right to vote right now because that is our most sacred right. That is the right that everybody fights for. That's the right we try and protect. And that is the right that gives us each a voice in our country. And it is relevant to our topic for today as well. to not take you too far back in time, I want to give a little perspective on how I came up with the peculiar specialty that I have. A specialty that focuses on Congress and the president, particularly when they come into conflict. I grew up in Alabama, and I grew up in Alabama in the 1960s. I grew up Jewish in Alabama in the 1960s. And that meant that I was a minority. That meant that I got beaten up a good bit. And that meant that even though I was not in the middle of the civil rights movement, I could see it from where I stood. I saw it all unfold in front of me, and just as that was happening, Watergate exploded. So my interest in law easily presented itself to me where I grew up. I saw how law made a difference. I saw how it brought order to chaos. I saw how it was designed to protect civil rights, to make them realizable and enforceable. And at the same time, I saw law bring a president down. At the end of the day, the conventional wisdom on Richard Nixon's presidency is that the Constitution worked. He was reelected, as you may all know, by a landslide margin. And then, shortly thereafter, the House, the Senate, and a special prosecutor, all three separately investigated him for possible misconduct in office, a possible connection to a bizarre burglary of the Democratic headquarters in the Watergate Hotel, a burglary that eventually found itself really at his doorstep because the burglars had his phone number, the White House phone number, on them. And after those investigations, it was discovered, among other things, that Richard Nixon had been taping conversations in the White House. And so everybody wanted to get them. The special prosecutor wanted them, the House of Representatives wanted it, the Senate wanted it, and eventually the Supreme Court ordered him to turn over tapes. It is significant to note that at the time, Richard Nixon ordered his other officials in the White House, ordered the people who work for him to cooperate with Congress. And that is why John Dean, his White House counsel, ended up testifying in front of Congress against Richard Nixon. Nixon actually had turned over most of the tapes, but there were a handful he hadn't turned over. Those are the focus of the lawsuit. And when he turned over those tapes, and the House Judiciary Committee approved 3 articles of impeachment against Richard Nixon, he met with Senate leaders who told him that if he stayed in office any longer, he was going to be impeached and he would not have enough votes to withstand a conviction and removal in the Senate, and he'd be forced out of office. His choice, Barry Goldwater, the senior Republican, told him was either to be the first president to be convicted and removed from office or the first president to resign. And we all know what he did. He resigned. Well, that's the backdrop to a lot of what we're going to talk about today. When I started thinking about impeachment, I was a senior in high school. I watched it on television. I watched this all unfold. And as I got interested in law, I began to think about to what extent does law matter outside the Supreme Court? We've seen to some extent in our lives and in our past how much law matters, of course, to the Supreme Court. But I got interested in the extent to which it might matter when the Supreme Court is not directing it, when the Supreme Court is not ordering it. To what extent do the other branches, presidents and Congress, actually care about the law? And that got me interested in impeachment because I thought that was one of the few areas where courts really don't get involved. They stand back and they kind of let the mess happen. And I thought after having written about it, we'd never see another presidential impeachment. You know, Andrew Johnson was impeached in the 19th century and ultimately acquitted by a single vote. Richard Nixon resigned before impeachment became any more of a reality for him. And so nobody was betting that impeachment would ever happen again. I published my first book on impeachment in 1996, and my publisher was an editor at the Princeton University Press. And he called me up and he said, wouldn't it be wonderful if a president got impeached right about now? And I said, I don't know that I would wish that upon the country. 2 years later, when the House of Representatives was considering the impeachment of Bill Clinton, he called me up and said, "Isn't this terrific?" And I said, "Well, you've got a bizarre sense of priorities. I mean, selling books is not exactly the most important thing I think we've got to deal with right now." But as fate would have it, I'd already begun working, not just in terms as a scholar. I'd already done my scholarship on impeachment, but having grown up where I did and grown up the way I did, I felt that it was important that a scholar not just write books, but also be able to speak truth to power, to be somebody who could be involved in the process, care about the process, learn from that process, bring that learning back to the classroom, maybe write about it more, become a better teacher. But as a lawyer, it was important to me that I didn't just practice law in the abstract, on a book about history, but I actually used that ability in the real world. And for me, the real world is Congress, which rates below cockroaches in popularity. Gives you an idea where Congress stands right now, or stoops, I should say, right about now. And yet here, my specialty was to be writing about an institution that nobody really cared about, nobody paid attention to, and about a subject that seemed to be completely historical. And lo and behold, after consulting with Congress in the late 1980s over 3 judicial impeachments and removals, I was called in by 2 members of Congress, Jim Leach, a Republican, David Skaggs, a Democrat, one day. They said, "Would you come into Washington to talk to us about impeachment?" And I said, "Well, sure," because that's important to me, helping to educate our leaders about what I do, constitutional law. And after talking to them for an hour, they said, "Well, we also want you to talk to the House." And I said, "I'm sorry, what do you mean?" And they said, "The entire House of Representatives." And I said, "Can I do that?" And he said, "Yeah, they're actually waiting for you." Little did I know, that I was then escorted by them into the old chamber of the House, where 435 members of the House were waiting, and I then spent 2 hours talking to them behind closed doors, which was, if you're a law professor, it literally doesn't get better than that. And they were, but because it was behind closed doors, there were no cameras, no staff. Everybody was on perfectly good behavior. Yelling, ranting, throwing things, calling people names or anything. We were talking about the law of impeachment. And at the end of it, Charles Kennedy, a Republican, and my representative, Bobby Scott from Virginia, came up to me and said, "Would you be willing to testify if we ever have a hearing on this?" I said, "I'd be honored to do that." And then a few weeks later, I got an invitation in the mail saying, "Would you come talk to the House Judiciary Committee as a joint witness called by both Republicans and Democrats to talk about the possibility that Bill Clinton may have actually committed an impeachable offense?" And when that was over, and we know how all that ended, Bill Clinton was impeached by the House for perjury and obstruction of justice, and he was acquitted by the Senate. I went back to my day job. And I thought I would never again see a presidential impeachment. I don't think any of us thought ever again, at least in our lifetimes, we would see a presidential impeachment. But we were wrong. We not only just saw one, we also, of course, saw its outcome, which was, I think, predictable. And so I thought what might be helpful is to look at the different explanations about what went on, the different theories about what went on, talk to you about why I think each one of them is wrong. That's my job as a law professor. And then think more broadly about what the ramifications may be for what we've just been through. So one theory about what went on, as you all know, the House impeached President Trump for abuse of power and obstruction of Congress, and the Senate acquitted him. One explanation for all of that is that the Democrats just hugely miscalculated and did the politically disastrous thing. They impeached him because they had the votes, and then in the Senate he was acquitted, where again everybody expected he might be acquitted if Republicans held together, and they largely did. And so the outcome was preordained. For the House to impeach the president when they know he's going to be acquitted is a political travesty. That's one theory. And it may explain to a fair degree what we saw. It remains to be seen to what extent the Democrats will be punished for this politically. They may well be. And to what extent it really redounds to the benefit of the president. It may well do that. But we all have to recognize that we've been here before. The President of the United States has been impeached before, when everybody knew he was going to be acquitted. That president's name was Bill Clinton. There was no doubt that he was going to be acquitted, as long as the 45 Democrats in the Senate at that time held together, and they did. They all despised Bill Clinton. One of the most remarkable things about Bill Clinton's impeachment isn't so much that he was impeached and he ultimately was acquitted, is if you read all the statements from over 70 senators, they all shred him. So he might have been acquitted, but in history, he's the second president to have been impeached. And when you read all those statements, everybody talks about how bad his misconduct was. Some thought it rose to the level of impeachable offense. Others describe it as a low crime rather than a high crime because he was lying under oath about a sexual relationship he had with a woman who used to work in the White House. And so impeachment against Bill Clinton might well have worked. It tarnished him. It marked him for all time. It left a record of reprimand against Bill Clinton, and it clearly has hurt him and his wife politically ever since. I don't need to, that should not be news to anybody. And it was, for lack of a better term, an albatross. It was something Hillary Clinton had to deal with herself when she became a candidate for president, among many other things. And so, whether or not it was a political disaster for the Democrats still remains to be seen. And at the same time, I think one has to recognize that for Democrats in the House, they were in a no-win situation. If they didn't impeach the president, then they would have been standing silently by while the president, according to all evidence that came forward, and by the way, the Democrats didn't manufacture that evidence. I am not somebody that really believes in conspiracy theories and other things. As a lawyer, I'm trained to trust facts, to believe in evidence, to believe what I read, if it's credible, and to believe what I hear, again, if it's credible, to trust those things I can kind of touch and feel, and not those things that are just made up. So we had a number of dedicated public servants come forward and say the President of the United States had solicited the leader of a foreign country to help his reelection. What they told us under oath was that what the President wanted was the announcement of an investigation against Joe Biden, not really an investigation, but just the announcement of an investigation against Joe Biden in Ukraine. And why was that? It could be that Joe Biden is the most corrupt human being in the history of the world. It could well be true. It could well be not true as well. Whether or not any of that is true or not true tells us nothing at all about Donald Trump. As a lawyer, the fact that this person over here is guilty does not make this person over here innocent. There is no legal principle in the United States where the fact that this person is guilty over here makes that person over there innocent, assuming they were not in some criminal conspiracy together. And I'm pretty confident Joe Biden and Donald Trump are not in any conspiracy together to do anything. So what we're left with then is an incomplete theory. If it's a political miscalculation by the Democrats, it doesn't explain everything that happened. It certainly doesn't explain the evidence that came forward. So there may be another theory. This other theory has a great deal to be said for it. That all of this, whatever relates to impeachment in the current situation that we just went through, is explained by partisanship. Look at the votes. In the House, mostly Democrats voted to impeach. Republicans uniformly voted to acquit or not to impeach. And in the Senate, Democrats all voted to convict, and one Republican, for the first time in American history, voted to impeach a president from his own party. That gives you an idea how strong party is. If we had to wait to 2020 to see the first time in American history when a senator voted against a president of his own party in an impeachment trial, that tells you how strong party is. And partisanship is very strong in this country and undoubtedly is getting stronger. And it may be stronger than anything else. It may be stronger than any constitutional commitment, any political affiliation otherwise, friendship or anything else. Political party affiliation may be so exacting and so strong it could explain what we just saw in front of us. But it might not explain fully what Mitt Romney did, and again, it might not fully explain all the witnesses because they were not, for the most part, partisans. Nobody invented this stuff. Whatever it is that Donald Trump did, nobody invented it. Certainly, Democrats didn't invent it. Here's something we have to come to terms with. Democrats are not that organized. They're not that powerful. And so it is unlikely they concocted everything to the point at which it took the form of witnesses who were not partisan, like Bill Taylor, West Point graduate, decorated soldier, and Lieutenant Colonel Vindman, again, not a partisan, maybe naive, but that doesn't make you a partisan, and again, a decorated war veteran. So partisanship may explain a lot about the votes, but it may not necessarily explain some of the facts, and it may not explain to us whether or not the Constitution is working now. So we still need another possible theory. So we come to a third possibility. And by the way, any and all of these things could be happening and could explain it. In other words, more than one factor could explain it. Another possibility is that whatever happened, the president did not commit an impeachable offense. This could be explained in different ways. And this takes us a little bit into constitutional law, so you'll have to be patient as I stumble into this area. So the Constitution tells us that a president, any president, takes office subject to the possibility that if he commits treason, bribery, or other high crime and misdemeanor, he may be subject to impeachment, conviction, and removal from office. That's what the Constitution says. We know what treason is. The Constitution defines it. Bribery is defined in federal statutes, but it also is defined in common sense. Bribery is using your office for personal gain. That's basically bribery. That's what it was in the colonies, in what is called the common law before we became a country. The common law is just a fancy term for judge-made decisions. And that's what preceded the Constitution. And so bribery has a common law understanding. But none of that explains what other high crimes and misdemeanors mean. Alan Dershowitz, a retired Harvard law professor, came forward for the president, obviously in his Senate impeachment trial, and said he went back and looked at the history, and he determined that whatever high crimes and misdemeanors means, they must mean crimes, actual crimes. Those things for which, if you did them, you could go to jail or prison, or perhaps even be put to death. It will come as no surprise to anybody who's known anything I've ever done on this subject that I don't agree with Professor Dershowitz. Professor Dershowitz also said at the end of his argument before the Senate impeachment trial that he was in a minority in believing that impeachable offenses were only crimes. In fact, he's in a minority of basically one. Everybody else who's ever studied this, including the one scholar he cited at Harvard, disagree with him. Everyone else who's looked at this basically agrees on the following: that other high crimes and misdemeanors are not terms we use in everyday English. I don't know about you, we don't even use them in our house. And I talk about impeachment way too much in my house. But my kids don't go around and say, oh my gosh, you just committed an impeachable offense. Or that's a high crime, or one of my sons is named Noah. Noah did something bad, but it doesn't rise to the level of impeachable offense. That is not how we talk in my house. That's not how anybody talks, I think, anywhere in this country. These are not common terms. And that's our first clue about what they might mean. We've got to look somewhere. That is, we've got to look where they came from. And they came from Great Britain. These are terms that the British used and the colonists used to refer to something that they all called political crimes. Now, what are political crimes? Political crimes are not the things for which you can go to jail or be put to death. Political crimes are the misconduct that people in office may commit by virtue of being in office, by virtue of the powers they wield in office. For example, only one person has the power to initiate an illegal war. I can't do it. Yes, law professors have lots of power, but we do not have the power to initiate war. But a president could do that because the Constitution makes the president the commander-in-chief. I can't pardon anybody who's been convicted of a crime, but the president can do that because the Constitution grants to the president the power to grant a pardon. I can't even lock anybody up, but a president or an attorney general could do that because they have the power over the enforcement of criminal law. So people in power, a judge, for example, could illegally put somebody in trial, in jail or prison. It's more typically prison, for not having committed a crime, but just because the judge doesn't like him. That would be a bad thing. And one might argue that's judicial misconduct. But it is not a crime. It's an abuse of power. And those other examples I gave you are not mine about what a president could do. They are the examples the framers gave when they talked about impeachable offenses in the Constitutional Convention. And I figure they must have known what they were talking about because they're the ones that put the language, other high crimes and misdemeanors, into the Constitution. Remember, the President of the United States says he cares about original meaning. No political party cares about original meaning more than the Republican Party. We heard almost nothing from the Republican Party about the framers during the president's impeachment. But if we look at what the framers said, they said lying to Congress about a treaty, about the conditions that would justify a treaty, is an impeachable offense. That's another example they used. Lying and using fraud to procure an election is an impeachable offense, according to George Mason. Not according to me, but according to George Mason. So, if we were to listen to the framers, and we are told oftentimes we should listen to the framers, they tell us that certain things that a president can do are bad and misconduct, but they are not the things for which a president could go to jail. And some of these things will rise to the level of being impeachable misconduct. So other high crimes and misdemeanors are abuses of power, breaches of the public trust, that's what Alexander Hamilton says in the Federalist Papers, and serious injuries to the Republic. That's what several other framers say, and that's what Joseph Story, one of the early Supreme Court justices who wrote an entire set of volumes called Commentaries on the Constitution, that's what he said. And William Blackstone, whose commentaries on British law were the basis for much of the American Constitution, said that impeachable offenses are abuses of power, breaches of the public trust, and serious injuries to the Republic. So therefore, we have a pretty good idea what that language means. Then the question becomes whether or not a president or this president committed any kind of actions that rose to the level of being any one of those things. That's the question that the House was considering, and that's the question that the Senate was considering. Now, the other possibility, besides the fact that the House was acting purely in a partisan manner, is that or even in a political manner, is this. It is entirely possible the House will suffer politically for what it did. So then it wouldn't just be for the sake of politics that the House did what it did. It's a perverse judgment in politics to do things that are against your self-interest. That's usually what leads somebody to go back to private life, get kicked out of government, kicked out of the House, or kicked out of the Senate. So why then might the House have done it if it wasn't politically advantageous? They might have done it because they wanted to establish a marker. They knew the president would likely be acquitted. The numbers all suggest that. When the president's party can control the Senate, the odds are the president would be acquitted. But the House may have done that in part because House leaders might have concluded, we're going to set down a marker and say when a president does these kinds of things, we think they are impeachable. We could get punished. That's almost exactly what Nancy Pelosi said. We may get voted out. Again, that's exactly what she said. But this is the stand we're going to take. And they did. And the president was acquitted, again, as everybody expected. So we're back to the question whether or not it's an impeachable offense. And I will leave it to you whether or not it is an impeachable offense, just like the framers left it to members of Congress to decide whether or not it is an impeachable offense. One of the other things that was said in defense of the president was, well, whatever he did, the money that he had delayed giving to Ukraine, supposedly to pressure the leader of Ukraine to make an announcement about Joe Biden, eventually was released. Yes, that is true. But what is also true is that it was not all released in time. So when Congress appropriates money, as it did for Ukraine, it sets a time limit or a time frame within which the money must be appropriated. And this money was not delivered within that time frame. So therefore, not all of the money appropriated was actually turned over to Ukraine. And not everything the president did was in that July 25th phone call. For example, what in the world was Rudy Giuliani doing in Ukraine? And now the president says he sent him there to find dirt on Joe Biden. And now the president has said that whatever Rudy Giuliani finds will be deliverable to William Barr, the Attorney General, and may be used against Joe Biden as a basis for prosecution in this country. So those are some of the different theories. Let me give you one last one before I finish. I've probably gone way too long. And now you're going to have to endure some law school. Because there is one more theory that may help explain what the president has done. And this theory is called the unitary theory of the executive. This is a theory in constitutional law. It's a theory put forward in a dissent that Antonin Scalia, when he was on the Supreme Court, issued in a case involving the constitutionality of the independent counsel. The Supreme Court of the United States has upheld the constitutionality of having a court appoint an independent counsel. And Justice Scalia was the sole dissenter in that case. And in that dissent, he put forward a theory of presidential power called the unitary theory of the executive. And it basically means this, that the President of the United States should be in the control of all executive power, period. And that could and actually does explain what the President's doing. The President said, I have all the information, but I'm not going to give it to you. That follows from the unitary theory of the executive. This is information produced in the executive branch. The President has decided he's not going to share that with anybody outside the executive branch. The unitary theory of the executive says that he can do that. He controls all the power. He controls the exercise of all executive power. So if he doesn't want to release it, he doesn't have to. If Congress issues a subpoena, by the way, a subpoena is a lawful order. We teach people in law school to comply with it, because if they don't, they break the law. We do not teach people in law school how to break the law. We teach people in law school how to comply with the law. But the President may defy that law because it's coming from Congress. And Congress is telling the President, you must therefore produce this information for us. No, under the unitary theory of the executive, he doesn't have to do that. He controls all the information within his branch. Doesn't have to release it to anybody he doesn't want to, not even to a court. Court can't tell him what to do. He's in control of all executive power. And therefore, whatever happened on that call was perfect, and Congress can't touch it. And the President does not have to cooperate with an investigation against himself. That all follows from the unitary theory of the executive. And then the only other question to ask about the unitary theory of the executive is, how do you hold a president accountable who's following the unitary theory of the executive? The answer is not impeachment, because a president can thwart it. The only other avenue is an election. That's the only other place you could hold a president accountable who's exercising the unitary theory of the executive, unless it's a president in his second term. So how do you hold a president accountable for whatever he does exercising the unitary theory of the executive in the second term? That is your homework, that is your assignment, and once you answer it, you will have a Nobel Prize winning book. Good luck. So I'm happy to take any questions or comments or anything else. Yes, ma'am.
I've lost my. How can a theory be higher than the Constitution? I mean, why doesn't the Constitution supersede a theory? It's just a theory.
Yeah. It's a very good question. So the unitary theory of the executive is a theory about the Constitution. And the theory is, or the proposition that Justice Scalia put forward in his dissent was, that the President of the United States, properly understood, should be able to control the exercise of all executive power. Article 2, we could all look it up, begins with the words, the executive power is vested in the President of the United States. And therefore, any executive exercise of executive power, executive privilege, for example, information produced for him or within his branch is under his control. Congress actually has passed a law that says that everything that the President does and people in the executive and people in the White House do, all of that should be preserved and put into archives. But the President is currently destroying information and not archiving it. How could that be? The theory that explains it is the unitary theory of the executive. Congress cannot tell the president, even through a law signed by some earlier president, whether or not he should preserve information or share it with anybody else. And therefore, the President of the United States is currently destroying documents and may not even be releasing all those things that are currently on the server, the most secure server. That's somewhere, we don't quite know where it is. We shouldn't know where it is because that wouldn't make it secret. And so what we're come back to is a theory about a theory that's really a theory about the Constitution. Now the question may be, what supports it? Fair enough. And what doesn't support it? As a law professor, I have to ask both those questions. So what supports it? Well, again, the opening words of the Article 2 say the executive power is vested in the president. Therefore, that must mean, or an inference from that may be, executive power, whatever it is therefore under the control of the president. Does it then follow that everything that the president does in his branch, within his domain, is under his control and may never be looked at or inquired into or scrutinized by any other branch? As a law professor, I would have to say possibly not. For example, what is an abuse of power? An abuse of power is an exercise of authority beyond what the Constitution permits. Therefore, an abuse of power is an unconstitutional act. So whatever else the unitary theory of the executive posits, it would not protect the president from doing something unconstitutional. Because if it did, he wouldn't be president of the United States, he would be a king. And this is what President Trump's lawyers argue before the Senate. He, the president, may not be subject to any criminal investigation while he's in office. The president of the United States may not produce any information he doesn't want to produce to anybody else. He doesn't have to comply with a subpoena from Congress if he doesn't think it's appropriate. He doesn't have, none of the people that work for him have to comply with any law from Congress, a subpoena, if the president doesn't think they should. What's left? Elections. But is it permissible for a president to solicit foreign interference on his own behalf in an election? Apparently the answer to that question is yes. That's one of the lessons we could take from the Senate acquittal. And then we're still back to the question, how do you hold a president accountable? And that again is still your assignment, still your homework. And I can promise you, if you write a really good book on that, you can win a lot of prizes. But it's a long answer to your question. My wife says I'm never very fun at these things. I always end up on a very down note. But before it's over, I'll figure out how to avoid that.
So I had essentially the same question, but I have another one. It may be too broad.
Sorry.
Can you say something about the rule of law in relationship to all this?
Yeah. Well, when I talk about the Constitution and talk about what is an abuse of power, it's an exercise of authority beyond the Constitution, I'm talking about the rule of law. So the Constitution tells us it's the supreme law of the land. It's the ultimate law. And if somebody doesn't follow it, who's supposed to follow it, who takes an oath to follow it, that is unconstitutional. So, again, going back to the framers, the President of the United States is supposed to, of course, negotiate treaties. But if he lies about it, that may undermine that particular authority he's got. And so we're left with is what is the rule of law insofar as the president is concerned. If you follow the unitary theory of the executive, in its most robust form, the president is the law. And you heard this in the early days of President Trump's presidency, when he said he couldn't possibly obstruct justice because he's in charge of enforcing the law. And if he chooses not to enforce a law or thinks this particular law shouldn't be followed, he doesn't have to follow it. Richard Nixon said the very same thing. In fact, when President Trump said it, he was quoting Richard Nixon. And so my only response to somebody who would say the president is the law is, well, Thomas Paine once said, the people are king. And then later, after ratification, several framers said, the law is king. But when the president says he's the law, that means he's a king. Because that's what the King of England was. The King of England was the law. And the framers rebelled against a king. I'm pretty sure that's right. That's why we broke away from England, because we didn't want to have a king. And if you go back and look in your homework on your book at the Declaration of Independence, the Declaration of Independence consists of articles of impeachment against the king. Now, why would the framers do that? They would do that because the king was not impeachable. And they were breaking away from the king, rebelling against the king, saying, you should be impeachable. So when they created an executive, they said that executive should be subject to impeachment. That's one difference between our president and a king. Another difference is our president's elected. It's not somebody who inherits the office. Another difference is the president of the United States is subject to checks and balances. And that means that not everything the president does is up to the president. For example, the president lives in a very, very nice house. It's called the White House. And the president travels on a really, really good aircraft called Air Force One. Who pays for that? Well, Congress must appropriate the money that would make all of that happen. The president can't do that. How do I know that? Because Article 1 says Congress has the power to appropriate money. So there are limits. There are limits to what a president may do. If he starts cranking out money for himself and by himself, that's not his power. That is literally Congress's power. So we can identify some of the boundaries of executive power in the Constitution, and it's a very long answer, but all of this, whenever we say that, we're saying this is what the rule of law commands. And the rule of law means you must follow it even if you don't want to follow it. That's what it means to follow the rule of law. And therefore, and this is what I had testified against, and I testified when I testified in the House, and I could be wrong. I've been wrong about a lot of things. I said that I thought that the President of the United States is not synonymous with the law. He cannot pick and choose which laws he follows. Because if he could, that's not the institution that's created in the Constitution. That's a king. A king chooses whether or not to comply with any particular law. But the President of the United States doesn't get to make that choice. How do I know that? Because the Constitution requires the President to take an oath to support and defend the Constitution. And that's the supreme law of the land, and therefore that's the rule of law the President must follow. Yes, sir.
You said so many misleading things, it's hard to keep track of all of them.
Sorry.
But one, you talked about impeachment. The Speaker of the House, Pelosi, had acknowledged that they'd been trying to impeach him for 2.5 years.
Right.
All right?
Right.
Had nothing to do with the perfect phone call.
Right.
As far as following the law, Obama didn't, and Trump has neither, followed the law on marijuana. They let all these states do it, even though it's a federal crime.
Right.
Then they can tell their prosecutors, focus here, don't focus here. So that's also misleading. We do have a treaty with Ukraine that Obama signed about corruption, but I won't get too far into that. The executive privilege, you say you can't, I mean, you keep quoting one justice like that's a big deal. It's one guy out of 9. There is executive privilege. The House did subpoena, and then they said, well, no, we're on a timeline, so we'll drop the subpoena, because they wanted to get it all done quick. That had nothing to do with law
Right.
and order. You referred about Russia. I think that was settled, I thought, but there wasn't any Russian collusion.
I don't recall mentioning Russia, but that's okay.
I mean, there were so many things there, it was just hard to keep track of all of them.
Okay. I'll do my best to respond to some of that. To begin with, again, there's no principle of law, there's nothing in the Constitution that says if this president did something bad, this president gets to do it. That's just not a principle of law in this country. To go back to the rule of law, that's the rule of law. The law applies to everybody, I would argue, even to the president. And if one president didn't follow it, it doesn't mean this president doesn't get to do the same thing. There's not a get-out-of-jail-free card that is passed to the president if some other president is thought to have done something illegal. But that is one of the defenses. And I'm just saying that defense doesn't hold legal water. But secondly, let me give you an example. If I said to you, a bill passed the House, and then it passed the Senate, and the president signed that, what is that bill now? It's a law. I didn't tell you what the vote was in the House, did I? What if it turns out mostly Democrats voted for it? What if Democrats mostly voted for it in the Senate, and the president signed it? It's still a law. The same is true for impeachment. The vote doesn't matter. The Constitution, which is our supreme law of the land, says the House has the sole power of impeachment. Therefore, if the House issues a subpoena pursuant to that power, why must it go to a court? The answer is it doesn't have to, because it has the sole power of impeachment. If it must, as a constitutional matter, go to a court, then the court has the power of impeachment. And this is why the House, not just against Donald Trump, but the House Judiciary Committee against Richard Nixon, said when he failed to comply with subpoenas, the third article of impeachment against Richard Nixon was the failure to comply with subpoenas. Why? Because subpoenas are lawful orders even when they come from Congress. And the president has no authority, according to the House against Nixon and according to this House against Trump, has no authority to defy a subpoena, a valid subpoena, that comes from Congress. The vote doesn't matter. We do not determine what's constitutional or what's not constitutional depending upon what the vote is. If I look at the Constitution, for example, and it says the House has a sole power of impeachment, and I'm told the House impeaches somebody, a majority voted, that's all I need to know. That's all any of us needs to know, whether or not the House has actually impeached somebody. So therefore, even if every Democrat votes for it and every Republican votes against it, if you have enough Democrats voting for it and they're a majority, that's an impeachment. However, it also follows from the very same principle that if every Republican votes to acquit the president in the Senate, and the numbers turn out to be the right way, he's acquitted. So if acquittal has the force of law, impeachment has the force of law. And that's, I think, what we've got. With all due respect, I really don't care what President Obama did. It makes no difference to constitutional analysis at all. It doesn't make any difference at all. I'm sorry, yeah. And on executive privilege, one last thing. On executive privilege, the Supreme Court of the United States ruled 9-0, that the President of the United States, Richard Nixon, had to comply with the judicial subpoena. That's the law of the land. And therefore, a president who takes an oath must follow that. And that's the law. That's currently the law of executive privilege. Now, as for the unitary theory of the executive, which I was talking about, you're right. One Supreme Court justice does not make the law, which incidentally tells us that if the President of the United States is acting pursuant to that theory, he's acting pursuant to a theory that has no foundation in law. You just made my argument for me. And therefore, he's acting unconstitutionally. Yes, sir.
Just one other theory about the
Sure.
House rationale.
Yeah.
Even if, though, in my opinion, even if they believe it might hurt them,
Yeah.
they would still do it just to dirty up Trump for the election.
I mean, that's entirely possible.
Like I say, you mentioned three theories.
Yeah, I'm not rejecting it. I said it's entirely possible. But it doesn't answer everything we know about the current situation. Incidentally, given the fact that Mitt Romney is the first senator in history to vote to convict a president of his own party, tells us how long parties have been determining impeachments and acquittals.
And how much Romney hates Trump.
Yeah.
You could decide you did it out of conscience, decide what you want.
No, I understand. I understand. But he's entitled, he's a valid U.S. senator, he's entitled to cast his vote, just like the other senators are entitled to cast their vote.
In the interest of time, we
Yeah.
have several more hands. I'm going to allow some other people to ask questions.
Hi. So I'm a common sense thinker, and want to go back. I had the same question of the lady in front of me. So in math and science, theories, even proven theories, are often advanced and taken to another level in order to progress
Sure.
society,
Sure.
or in order to progress us as a people. With that thinking, what will it take to advance this theory of executive power? I'm just thinking it can't, because it's an interpretation
That's
of
right.
what they believed, and so
That's right.
what would it take to progress that?
It's a very fair question. So the way typically in constitutional law something gets established is through two or three different means. One is if Congress does it repeatedly. That's called historical practice. So that's one possible source of authority. A second is that the Supreme Court says it's okay. That's a second source of authority, a Supreme Court judgment, Supreme Court precedent. And the third is if all three branches come together and agree that something is lawful or is doable, then that becomes another. That actually is that's the firmest basis in law. The most famous example of this that illustrates how this works is Brown versus Board of Education. For years and years and years, many states had passed laws that said that the races had to be segregated in public facilities. In Brown, in 1953, the Supreme Court of the United States said that forced or state-mandated segregation violates the Equal Protection Clause. And therefore, all those laws, they eventually would all fall down. There had to be a string of Supreme Court decisions that said that. However, states still resisted that decision. And the president didn't enforce that law until really late in the 1950s. And the only time when Brown was fully enforced was around 1964 and 65, following the 1964 Civil Rights Act, the 1965 Voting Rights Act. Then you had all three branches agreeing on that as a principle, which is why today, I think just about anybody you talk to, Democrat, Republican, says the law of the land is the federal government, states may not require segregation. Yes, sir.
You spoke earlier on the rule of law,
Yeah.
and how the country was built upon those principles. Do you believe that because Trump was acquitted, that he was held accountable for what he did, and because of such a strong partisanship in the government, that if the party doesn't hold power in both the House and the Senate, that a president will ever be held accountable?
Yeah, it's a great question. So first of all, I can't really render a judgment on the accountability of President Trump because, in a sense, the Constitution has spoken. That is, the impeachment process is over. That he's acquitted. There's going to be an election. We'll see what happens there, and then history still has to work its way out. So accountability, when you're president, operates in a number of different venues. The ballot box is one, historical judgment's another, popularity is yet another. All those have to work themselves out. And so they're beyond they're beyond my expertise. My expertise is supposed to be the Constitution. Secondly, you raise a really good point about the nature of the impeachment process. So another theory, which I didn't mention because I was trying to save time, and I was trying to avoid real depression, is that the Constitution is broken. And I'm not the only one that's putting that forward. A lot of people have been putting that forward for some time. There are different reasons why we can say the Constitution is broken, and they don't have to. And so, first of all, the rise of political parties happened after the Constitution was ratified, and the pull of political parties is something the Constitution wasn't designed to deal with. James Madison put forward the argument on behalf of the framers that the whole system of checks and balances in the Constitution is designed to prevent a faction, a self-interested group, from gaining control of any particular part of the government. But political parties have become factions. They've become tribes. My tribe, whatever it is, has to kill you. It doesn't matter winning this election. I have to kill you, and I have to win in every way imaginable. This is how partisanship is today. It's understood at the tribal level, and not the constitutional level. Secondly, the Senate is no longer structured the way it was originally. Originally, the Senate was designed for people to be selected by state legislatures. And then later, the Constitution was amended to allow for popular election. So now senators are not really functioning as the framers ever envisioned. They are now functioning much more like the House, which, by the way, the framers didn't trust. How do we know that? Because the Constitution is structured in such a way that the House is unable to complete any constitutional action. There's no area in which the House has the final word. Yes, the House may impeach, but that's not the final word of anything. If the Senate never took it up, it still would mean almost nothing. So if the Senate is more like the House now than it was originally, that too is a problem. And then we have to think about social media mapped onto all this. All these things together have undermined a lot of the checks and balances the Constitution was originally designed to put into practice. And with all that happening, it's hard to think of the Constitution as working perfectly. For example, political parties have taken over the Electoral College. The Electoral College was thought to be an independent voice, but now it's just basically effectuating whatever the parties have determined. That's not how it was originally designed. So it's a really great question, and so you're right. If a president's party controls one or the other chamber, it likely means impeachment's not effective. It's not an option. And here's the practical reality. Impeachment is always going to arise in a partisan atmosphere. Why is that? Because criticism of a president is not likely to arise within his own party. here's one of the conundrums we have to face, and I had to face in the House, and others have to face as well. And it's a neat little conundrum created, I think, that the president's created, and it's very effective. And that is, you cannot criticize him ever. And the reason is that if you did, it shows that you're a no-Trumper, you're a Democrat, you're unpatriotic, or anything else. So let me ask this question. Where would credible criticism come from? It could come from nowhere. Because if Mitt Romney, oh, he hates Trump. I must hate Trump. So one thing to think about is every president, even this president, should be held up to be accountable, and that means to be criticized. And is it possible for people in the president's party to criticize him? I don't know. It sounds like the answer would be no, because the immediate reaction will be, you don't have the authority or credibility to do that. Why? Because you criticize him. Well, good luck. That's our dilemma.
Good evening. I have two questions, and that was a perfect segue.
I don't mean to get started. No.
It was a perfect segue into my first question, because I'm curious to know if it's possible for us to ever change the Constitution. If it's not up to the standards of what it was when we first created it, how can we unratify what's been, like, what was that original idea, and be more forward and futuristic thinking into how our society operates and works now when it comes to politics? And then my second question, you mentioned if impeachment doesn't work, that it's elections being like one of the options of getting whoever elected in out. With rumors of Russian meddling and hacking of elections, what's our other option?
Well, the short answer to the second one is I don't know. Again, maybe I'm naive, but I'm going to trust what the leaders of our national intelligence services say, which is that Russia's trying to interfere in the election. And maybe that makes me un-American, so be it. But I'm going to trust what they say because that's their job. And then let the chips fall where they may. In terms of whether the Constitution could ever be amended, I think it's highly unlikely. You need such a supermajority, so many states to agree for there to be a constitutional amendment, it's practically impossible. Which, by the way, also takes us back to one thing else, one other thing about the Constitution, which may support further the idea the Constitution may be broken. We've had 3 presidential impeachment trials. They have all resulted in acquittals. And one of the reasons for that is not because of party, it's not because of hatred, it's because the Constitution requires at least 2/3 of the Senate to agree for conviction removal, and getting at least 2/3 of the Senate to agree on anything is virtually impossible. And to agree on something as seismic as removal of the president is now, I think we can all realize, is practically impossible. Only a third has to resist that. Only a third of the Senate has to say, you're going way too fast, there's a problem here, or any number of other things. And that tells us impeachment may not be an effective means for dealing with any presidents, not just this president's, but any president's misconduct. How do I know that? Because Johnson was acquitted, Clinton was acquitted, and I'm going to guess the next president will be acquitted too. I'm sorry to, I wish I could come up with a more, a more positive outcome, but maybe I'll put it this way. James Madison believed that the ultimate safeguard, the ultimate fundamental foundation of the Constitution was the public's interest and openness to being educated, to being enlightened. Remember, the framers were the children of the Enlightenment. They believed in facts, they believed in science, and they believed in you. And they believe that education is the most important thing. So this is the start of whatever happens. It starts here. It starts at a university. It starts in the dialogue and the study that people have about their own constitution and their own world and their own politics. This is the thing that saves America. Whatever else happens, education is the thing that matters most.
So I would like to ask one last question.
Yep.
While we ask everybody to pull out your phones and fill out the survey with the QR code, if you would not mind, while I ask the last question. And you just made such an upbeat statement. I hope I don't get us negative again.
Well, that's going to be on you. It's not going to be on me.
It'll be on me.
Yeah, right.
But I can't help but think about the contradictions that we're discussing around the unitary theory of the executive. And I'm thinking about the Justice Department. My understanding is the current practice is that the Justice Department believes that you cannot indict a sitting president.
That's right.
So if you cannot indict a sitting president,
Right.
then in effect, a president is above the law.
That's right.
So in effect, in practice, the unitary theory of the executive is in fact correct. It's how we function as a nation state right now, given the practices, the policies of the Justice Department.
Yeah.
Yet on the other hand is everything else you've told us and we all know about the value of and the principles enshrined in the United States Constitution by the framers of checks and balances, that no one is above the law, that we left the United Kingdom to leave a kingship and to establish a republic and to establish a president that's not above the law. So how is it that we have in practice the unitary theory of the executive seems to be the practice of our Justice Department, but it's in such stark contradiction with the founding principles of an original interpretation of our founding documents, that no president should in fact be above the law. How do we square that circle?
It's a really terrific question. So one possibility is the Justice Department is wrong. And I have testified to that effect in last July. And most constitutional scholars probably think the president, for institutional reasons, should be immune to a criminal indictment and prosecution while he's in office. I've long thought that was wrong for the very reason that's kind of the premise of your question. But it's only a Justice Department opinion. It may or may not be ultimately the law of the land. And the Justice Department tends to be kind of pro-presidential and pro-executive. I think, as you know, the thing that concerns me much more now is trying to get a handle on whether or not it's even meaningful to talk about holding a president accountable if a president really is not indictable, and if a president is acting on the basis of unitary theory executive. Because it also means this. Attorney General Barr has stopped 6 criminal investigations into Trump. Now, if I were to say to you that Eric Holder had stopped 6 criminal investigations into President Obama, I assume somebody here would get really angry. I would get angry regardless of who the president is. I mean, my client, so to speak, the thing I care about is the Constitution. That's what, and so I don't, for me, you could take the name of the president out of any equation and just ask institutionally, should the president be subject to this kind of limitation or have this kind of power? I think that for the Attorney General to be doing that takes us to a whole new place. And I think one reason why we end up thinking the unitary theory executive is the basis for the president's actions here is because it's the one concept that seems to explain everything we're seeing right now. And then it kind of leads us back to a bigger question, which is, okay, if the Justice Department is not wrong, how do we hold the president accountable? And I think the only other answer is the right to vote. The right to vote has to be protected. There's a reason why the right to vote is under assault everywhere in this country. Why do you think that is? Why do you think that just it so happens that it's getting harder and harder to exercise the right to vote? I'm not convinced it's voter fraud. No expert has found enough evidence of voter fraud to explain why it would be needed in my state, North Carolina, or any number of other states. And in law, we oftentimes interpret things based on their effects. From the effect of something, we might be able to figure out, okay, what's going on. And then we know the effect of tightening voting requirements is to make it harder for some people to vote. I'm not inventing this. So why do you think that is? That's your other homework project. I failed. I ended on a very...
And on that note, thank you very much, Dr. Gerhardt,
Thank you.
and thanks to all of you for coming tonight for the lively discussion.